Welcome back to Breaking History, the Supreme Court Historical Society's show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined by Gerard Magliocca, who is the Lawrence A. Jagan Professor at the Indiana University Robert H. McKinney School of Law and the author of numerous scholarly articles and 5 books so far. The first, Washington's Heir, The Life of Justice Bushrod Washington. The second, Andrew Jackson and the Constitution, The Rise and Fall of Generational Regimes. The third, The Tragedy of William Jennings Bryan, Constitutional Law and the Politics of Backlash. The fourth, American Founding Son, John Bingham and the Invention of the 14th Amendment. And the fifth and most recent, The Heart of the Constitution, How the Bill of Rights Became the Bill of Rights. And he keeps on writing. His next book, titled The Actual Art of Governing, is about Supreme Court Justice Robert H. Jackson, and it will be out soon. We are here today to talk with Gerard about his latest work, an article in the Journal of Supreme Court History titled The Untold Story of Robert Jackson's Youngstown Concurrence. That article builds on the work he's put into his forthcoming Justice Jackson book, about which we'll talk a little bit more later. Welcome to Breaking History, Gerard.
Thanks, Ross. Great to be here. I've got my Supreme Court Historical Society mug, so I'm ready to go.
Well done. Thank you very much. We only have about 20 minutes in which to discuss one of the most important judicial opinions in American history, Justice Jackson's concurrence in Youngstown Sheet and Tube versus Sawyer, which was decided by the Supreme Court in June 1952. So we'd better move briskly. Let's start with a quick look at what the case was about and what Justice Jackson's role in the court's decision was. Gerard?
Yeah, so the case was about President Truman's decision during the Korean War to seize the nation's steel mills and operate them on his own because a strike was looming that would have shut down steel production throughout the country. So the president did this on his own authority, citing his role as commander-in-chief and the need for national security. This was challenged by the steel companies, and the Supreme Court held that the president's action was unlawful. Justice Jackson wrote a concurring opinion in that decision in which he laid out a framework of analysis for why he thought the decision of the president was unlawful that has become kind of the most important text for modern separation of powers analysis when you have conflicts between the president and Congress.
Thank you. Now, how about if we move to a couple of key documents that are central to the article that you have in the journal? The first is Judge Augustus Hand's opinion in an earlier case from 1921, about 30 years before Steel Seizure. And the second document, which in large part you discovered, not in terms of the document itself, but its importance to this case, a memorandum written by a Department of Justice lawyer at the time, Golden Bell. Actually, not at the time. He was there in the 1930s, and I think we'll hear a little bit more about him from you in a few minutes. But how did these two opinions, or these two documents, Judge Hand's 1921 opinion and Bell's 1937 memo, fit in with Justice Jackson's opinion in 1952?
So in Justice Jackson's file on Youngstown, there is a handwritten note in which he writes down the citation of Judge Hand's opinion and asks for it to be brought to him. Now, Augustus Hand was the cousin of Learned Hand and was himself a very distinguished district judge and then later appellate judge. And Hand had written an opinion in a district court case in 1921 that involved the president's decision at the time to prevent the landing of a telegraph cable in the United States. And the president did that on his own authority, and Judge Hand rejected the president's authority to do that basically by looking at congressional legislation on that subject. So he said in this district court opinion, the president's authority depends in part on whether Congress has authorized the president to act, has done nothing, or has prohibited the president from acting. And then Hand proceeded to say that the president lacked any sort of Article 2 power to prevent the landing of a telegraph cable in peacetime. This, of course, is very similar to the analysis that Justice Jackson made famous in his concurrence, where he had three categories to sort executive action, saying that its lawfulness depended in part on whether Congress had authorized the president to act, had done nothing, or had prohibited the president from acting. So that basic framework from Judge Hand's opinion was very important for Justice Jackson's subsequent analysis. Now, Jackson did cite Judge Hand's opinion in Youngstown, but only in a footnote where he included it with a lot of other cases on separation of powers questions. So he didn't really acknowledge the importance of Hand's influence on his thinking. And in part, you might say that's because the opinion was written in a hurry and there was only a very expedited proceeding, in the sense that the suits were filed in April of 1952 and the Supreme Court decided the case in June of 1952. So all of the opinions were written quickly and perhaps didn't get the full sort of treatment or sort of thoroughness that they might otherwise have had in terms of how they handled sources. But certainly Judge Hand's opinion was one that was an important influence on the concurrence. Now, the Bell Memo was a secret document at the time, written in 1937 by Bell, who was an assistant solicitor general in the Justice Department. And the memo was about executive power, a very thorough treatment of the subject. And Jackson had a copy of this memo that he had been given by Tom Corcoran, who was an important lawyer during the New Deal and very well connected all throughout the government. And one of the things that this memo did was use the phrase zone of twilight to describe some situations in which presidential action and its legality is uncertain. Now, of course, that phrase was then later made famous by Jackson in his concurrence in describing a circumstance where Congress had not legislated at all and there was great uncertainty about whether the president could act on his own or not. The memo did not become public until 2013. It was part of a kind of, you might call, declassification or release of old confidential memos by the Justice Department on matters involving all sorts of subjects. So, and when that memo was disclosed in 2013, there was some notice given to the fact that the memo used the phrase zone of twilight well before Jackson had used it in his concurring opinion, and wasn't that interesting. But when I looked at the Bell memo, you kind of put it side by side with the concurring opinion, you see that there are many other similarities, which lead to the conclusion that Jackson used the memo as a kind of source for his analysis. Now, this included similar sources, similar quotes, and in two instances, quotes that were actually lifted by Jackson from the Bell memo into footnotes of the concurring opinion. I mean, if you look at the quotes, and I have them fully quoted in the article, nearly identical. And so there is no doubt that there was, in effect, an unattributed borrowing of the quotes. Now, part of my goal in pointing all of this out is to give Bell the credit he deserves. Here's someone who was basically a civil servant and it did some important things to help form the backbone of one of the greatest opinions that we have in constitutional law, so he should get some share of the credit. It wasn't really possible for Jackson to do that without revealing a memo that was secret. Now, maybe he could have done so afterwards in some fashion, either privately or publicly. However, he did die 2 years after Youngstown was decided, so perhaps that just was something he would have done eventually, but didn't get around to doing. Judges often borrow things from other sources without giving it the kind of attribution that a professor would, or even a student might in writing a paper. I don't know that we would then say that, therefore, there's something terribly wrong about it. though I think reasonable people could differ on that score. But there is no doubt that Judge Hand's opinion and the Bell memo were both important sources as Jackson was drafting his opinion over the course of just a few weeks.
Now, in another context, you mentioned to me another secret memo or confidential memo that Jackson also used in a different opinion, one that he received from President Roosevelt. Is that correct?
Yes. So when Jackson was Attorney General, he received a kind of private memo from President Roosevelt on the constitutionality of the legislative veto. And Roosevelt gave him this memo more or less for the historical record and said, you can disclose this when you think it's appropriate. And in an early draft of the concurring opinion in Youngstown, Jackson considered and started to talk about this secret memo and say, I've decided this is the time I'm going to disclose it. Okay, then he decided against that in the subsequent drafts. And instead, he wrote a law review article shortly after Youngstown was decided in which he talked about this secret memo and how it came to be and what it said and his own views on it. So it's clear that Jackson had many cards up his sleeve, let's say, and maybe just decided that an opinion of the court or an opinion for himself writing in a case was not really the appropriate time to make a revelation like that. Now, could he have written a law review article about the Bell memo? I suppose. Or could he have written Bell a letter? Hey, I just wanted to thank you for your work, and I used some of what you did in my opinion. Those things are possible. I don't really know what happened to Bell after World War II. Before the war, he had some other posts in the government, including in the Philippines. But it's possible that this article or what I'm going to say about Bell in the book might draw further attention to him, and perhaps there are living descendants who might reach out and tell me something more about him or what happened and whether he didn't get some sort of acknowledgement from Jackson.
Oh, that's an intriguing prospect. So it sounds like what we have with respect to the Bell memo is that Jackson clearly borrowed and clearly in some mix of the rush and bustle of getting this done quickly and maybe just a choice about so propriety and discretion in terms of disclosing Bell's contribution, didn't acknowledge it at the time in the opinion, but might well have done so privately, and we just don't know. And might well have written another law review article or delivered a speech later, as he did with the Roosevelt memo, talking about the Bell memo. But unfortunately, he died a couple of years later, right? Jackson, that is. And so it may well be that any intention of that sort was cut off by fate and bad health.
Yeah, it's possible. And also, it's fair to say that judges often or sometimes borrow from briefs, borrow from other publicly available sources, maybe without giving full credit, but maybe on the assumption that, well, people will see that there are these similarities and will understand that without having to be told. Mm-hmm. And Jackson himself was not a stickler for citation. I mean, he did cite, for example, poetry, and he didn't include a source that says, here's where I got this poem from. But you might think it presents a more complicated problem when the underlying source is a confidential one. And presumably one only he had access to, because there's no indication that any other justice on the court would have had a copy of the Bell memo. So that raises some interesting questions in and of itself, but for another time, I guess.
Yes. And perhaps for another article in the future, we can hope, right? Now, one of the things that we certainly should cover, particularly given that at the time in 1952, this was an opinion written by one justice, just for himself. This was a concurrence in a weighty decision by the court, but still just for one person in 1952. But 70-odd years later, it is a pillar of constitutional jurisprudence. How did that happen?
So the answer to that question is Watergate. The first 20 years or so after the opinion came out, it didn't get any special attention. It was just one of many opinions that people might look at or talk about. But when President Nixon was trying to do various things unilaterally during his administration, especially keeping the Watergate tapes out of the hands of the courts, people were looking for some source that they could rely upon that would explain why the president did not have this kind of sweeping authority, and that we had to look to a more balanced or practical understanding of separation of powers. And Justice Jackson's concurrence fit that zeitgeist or environment very well. And it was cited independently by courts, by scholars, Arthur Schlesinger in a notable book on the imperial presidency, and Archibald Cox, the first special prosecutor for Watergate, cited it quite a bit in his brief to Judge Sirica in the case in the district court in the District of Columbia about the Watergate tapes and the Watergate prosecution. So from there, when the case reached the Supreme Court in 1974, United States versus Nixon, that was the first Supreme Court opinion to quote from the concurrence. And really, that case, because it was so highly publicized, so prominent, launched the concurrence into the stratosphere in terms of its influence and something that people wanted to use. So that was the crucial moment, because then after that, everybody was trying to climb on the train of Justice Jackson's concurrence, whether it be courts, Congress in legislating, scholars in writing about separation of powers. So a source, a legal opinion, and indeed you might also say a movie or a book, often is not popular the day it comes out. It takes time. You know, the famous story, The Wizard of Oz was not really that successful at the box office, but then later, what happened? Well, it got on television and it was replayed a lot on TV, and then it found its audience and became like kind of the classic film. Okay, that also took about 20 years. So, I mean, judicial opinions often are in a situation where they don't, they need some event to sort of focus attention on what they're saying. And that's really what happened with Justice Jackson's opinion during Watergate.
So in 1974, it becomes an influential view, an influential analysis. It is persuasive authority, but it's still just one judge writing just for that judge. Is it still today important? Merely may be the wrong word, but is it still most important, or still important just because of its reasoning? Or has it become somehow more substantially law, more substantially precedent, even though it was originally just a one-for-one opinion?
Yes, I mean, it is law now, and that happened in 1981. In an irony, Justice Rehnquist, who wrote for the court in Davies and Moore versus Reagan, turned the Youngstown Concurrence into the formal test that the court uses for separation of powers cases involving the president and Congress. And Rehnquist had been Jackson's law clerk during Youngstown and had, in effect, worked on the case. So it's really the only time where a justice's law clerk then took a case that law clerk worked on and turned it into the law of the court or the law of the land as a justice. Now, taking that one step further, Chief Justice John Roberts was Justice Rehnquist's law clerk when the Davies and Moore case was decided in 1981. And of course, now he has used the concurrence a number of times in his opinions, most recently for the court in Trump versus United States.
Oh my goodness. So the law may not be a seamless web, but it is all interconnected.
Absolutely.
So before we go, in our last couple of minutes, if you don't mind, could you tell us a little bit about how you came to make such a sort of a fascinating, eye-opening connection between the Jackson Concurrence and the Bell Memo at this late date. It's been 70 odd years since the opinion was written. It has been now, Watergate was 50 years ago. It's been more than 50 years since that opinion became a jurisprudentially and historically significant opinion. And yet you've made arguably a major discovery about the inspiration and the drafting of this thing. How did that happen?
Well, first of all, the Bell Memo didn't become public until 2013, so no one before that really could have made this discovery. Second, I initially was going to call this book Zone of Twilight, and so I wanted to see, where did Jackson get that phrase from? Did other people use it? Did he get it from Rod Serling? What was the origin? And when you did a search, you came across the Bell Memo because it used that phrase. And so then I went and read the Bell Memo and realized that there were other similarities between that memo and the concurrence, especially once one or two of the quotes seemed to be identical, then that sort of rang the bell, and no pun intended. And so basically, it's somewhat serendipitous. The document had to be available. And then there had to be the thought that, okay, I was looking at a certain aspect of the concurrence that happened to get a match between the Bell Memo and the opinion. Then once you had that match and then you pushed it a little further, you saw that there were other connections and matches. So that's just how research works sometimes. You just try to find a clue, and you get a thread and you follow it, and maybe it leads somewhere and maybe it doesn't, but you hope that enough things lead on to other interesting things that you have a story that you can sort of build out about whatever it is that you're looking into.
And in this, what you just described, you're a great role model for all of my law students, all of yours, for junior colleagues everywhere. You chase every one of these things down to the tip of its root. You basically, what you did was you found the whole story of this Zone of Twilight, and in the course of it, turned up all sorts of other gems that collectively fit together in this remarkable discovery. It's pretty neat. So there is a lot more that Gerard could tell us about Justice Jackson and Steel Seizure and Jackson's jurisprudence. A whole book's worth, at least. And you should be able to read that book soon. Gerard, do you know yet when and where it will be available?
So it will be available from Oxford University Press, probably at the end of this year or perhaps early next year. I don't have the exact date yet. Coming soon.
Coming soon, and certainly soon enough to be put at least as a coming soon holiday gift this coming season. Yes?
Yes, absolutely.
Very good. Well, you can get a preview of this book, which does sound fascinating, a start on it of a sort, by reading Gerard's article in the latest issue of the Journal of Supreme Court History, Volume 50, Number 1. And you can subscribe to the journal by becoming a member of the Supreme Court Historical Society at www.supremecourt.org. Thank you very much for joining us for this edition of Breaking History. We will be back soon with another new and interesting look at the past and the court. Thank you.
Thank you.